Okay. Good afternoon, ladies and gentlemen. Welcome to our live podcast. This is Dr. Olu Asekun here. Welcome to another beautiful Wednesday. Please remember to invite your friends, family members, colleagues at work. Invite us as we proceed with what part are we today? 12. Okay, so as we proceed with part 12 of the immigration update under the current administration. Hopefully, we will soon go back to our regular way of doing podcasts, but for now, we have to continue because every single week, we continue to have new trend and new information. So today, we are going to start with a few updates from last week. Between last week, Wednesday, and now, this administration is not short of news and new policies and all of that. Many of the executive orders that have been signed before, DHS is now in the implementation stage. So they are now implementing, thank you. They are now implementing many of these executive orders. For example, DHS updated its policy on sexual orientation of applicants. Now, officially, USCIS is now recognizing only two sexes, that is, male and female. Male and female, they have updated all the immigration forms. So you no longer have the opportunity to choose anything outside of those two. You are either a man or a woman. So that policy is currently being updated. Some people may see that as a sign of good things, while others may see that as troubling. But whatever it is, that policy is currently being implemented. The next thing, which is very, very unfortunate and very, very painful for me personally. Painful because this administration is making this job very, very difficult for us. Now, I'm in a position, I'm being put in a position where I have to apologize for telling the truth. The agreement between the DHS and IRS, that agreement has now been finalized. The IRS has now agreed to provide information to DHS, information of people who are undocumented. This is extremely painful, and I'm personally hurt by this decision. Although a lot of IRS leadership objected to it. In fact, the top 3 leaders of IRS, they resigned in anger over this agreement. And I can tell you that this agreement is going to cost the US government some money, because now people will be afraid of filing taxes. The law requires that everyone making money in the United States, whether you live here or not, you are mandated to file taxes. But the law also makes IRS an independent agency of government. But now, the DHS is trying to use the information obtained by IRS in the course of filing taxes to use it to deport people. How do you now encourage people to file taxes? How do we, as lawyers, advise people to do the right thing? As I said, I'm in a position now where I have to apologize for telling people to do the right thing. And I do apologize. And I'm making a personal promise here. If you have listened to our podcast, if you have listened to me, where I told you the right thing, which is what the law says, that whether you have papers or not, you are required to file taxes. And if you have taken steps following that advice, I assure you, if anything happens, please contact me. I will represent you for free. But of course, you will have to show evidence that you actually followed my advice, not that everybody who just filed taxes and now got in trouble, you are going to call me. You will be wondering, how will I know? I will know, because when I did that podcast where I stated that everyone making money is in the US, whether you have papers or not, you are required to file taxes. We received a lot of calls in this office asking for direction on how to do it. Some sent emails asking for direction. If you fall into any of those categories and you actually file that taxes, if immigration pick you up or anything happen, please contact us in this office. I guarantee you I will represent you for free. Once again, I apologize for telling the truth. This is the situation we have found ourselves. This is the country that our beloved America, God's own country, this is what it has turned to under this current administration. And it is very, very painful. Another thing that happened between last week and now is that DHS has continued to revoke F1 status, student status. They have continued to revoke visas for students. It is getting to a stage that is becoming difficult to even understand what criteria they are using to revoke it. Because initially we thought it was only those who participated in protest and all of that. But they are going beyond that right now. They are revoking visas for a lot of students. Students from China, students from Africa, from Arab countries, from different parts of the world. Students who have not done anything to violate their status. These people are revoking their status. They are revoking their visas. Although a lawsuit has now been filed. There is one Chinese guy who is currently doing his PhD program. They just revoked his visa on Monday, so he has filed a lawsuit. And of course, a lot of organizations have offered to assist. And I know that some other organizations have offered to file amicus brief in his support. Amicus simply means friend of the court. Those who will file independent brief as a friend of the court is called amicus brief. We don't know how this is going to end, because even the Supreme Court continued to allow Donald Trump to use the Alien Enemy Act to deport people. I honestly, I'm really, I don't know how to express my mood right now, because disappointment is an understatement. What is democracy? It simply means there is rule of law. What is rule of law? It simply means everybody will follow the law. Nobody is above the law. Here we are seeing people who are in position of authority and they are acting as if they are above the law. If these things were to happen in African countries, they will say, oh, they are jungle, they don't have regard for law, they don't do this, they don't do that. Here, we are in America, the country that is supposed to be the greatest democracy. Here we are, finding ourselves acting as if we are in the jungle, acting without the rule of law, acting without respect for laid down rules and procedure. Here we are. Another unfortunate news between last week and now is that anyone holding the passport of South Sudan, whether you are in the US or you are outside the US, visas have been revoked for anyone that is holding South Sudan passport. Honestly, I don't know the reason. So since I don't know the reason, I can't comment whether this is a good or bad decision. But anyone holding South Sudan passport, if you have a American visa on it, that visa is revoked. It does not matter where you are, whether you are currently in the US, you are currently outside the US, all visas for anyone holding South Sudan passport is revoked. I assume probably it is because of the war there, but again, because I don't know, I'm not going to speculate and I'm not going to comment on it. We have a long way to go today because we have a lot of questions that we are going to cover. And I believe, did you say we answered this last week? And I can't even read it, it's too small for me. So if there's a way you can, you might want to type it out. I can't read it. The letterings are too small. So we are going to go into questions right now. We are going to start answering the questions. Let me know where to start from, the ones from last week.
I'm still typing some of them, but you can start from there.
So this, okay, which one? This one? Okay. Yeah, so we are going to go into questions and answers today, right away. We have a lot to cover today. And the IRS news is not really pleasant news for me at all. And honestly, it's affected my mood. And hopefully I'll be able to recover, but I'll try my best. So the first question. Hello, sir. Thanks for all you do, sir. Sir, how long does it take to receive a response from USCIS when requested for FOIA? Well, there's no specific time, but it depends on a number of factors. You know that electronic filing is not something that's been going on for a long time. I remember when I started practicing immigration law, if you request FOIA, USCIS will mail you bunch and bunch of papers. In fact, they will pack them in containers and ship to you. Subsequently, they started sending it on CDs. No, before CD, I think they started with floppy drive. You remember floppy drive?
I didn't know. I don't think I was working for your office.
Yeah, they started with floppy drive. Then from floppy drive, they moved to CD. But right now, everything is electronic. You just download it now. They just send you a link now. They send you a passport and you log in and you download it. So the point I'm making here is that it depends on when your case commenced. If your case is already in electronic form, FOIAs could be anywhere between 1 week and 6 months. But if your case is still in the paper form, sometimes it may take longer. And it also depends, where are you doing the FOIA? Are you doing the FOIA with EOIR or with DHS? Generally, FOIAs with EOIR, they are much faster. I mean, we've seen FOIA within 48 hours. If it is from EOIR, we've seen response within 48 hours. But when it is from USCIS, like I said, it takes much longer. But it also depends on whether this case has been converted to electronic form or whether it is still in paper form. When it is still in the paper form, then it takes longer. So the next question. Good afternoon, Dr. Asekun. Thank you for all your help and support, sir. God bless the work of your hands, sir. Amen. I say amen. Please, sir, can you please scroll it up a little bit? Yeah. Please, sir, is anyone with VAWA pending case an illegal alien because I don't understand the whole system any longer. Well, the word alien simply means foreigner. I have no idea why Donald Trump is reinstating it. During Biden administration, the Biden policy was that they should stop using the word alien for foreigners. But as soon as Donald Trump came back, he reversed the policy and resumed calling people alien. So aliens simply means foreigner. However, whether you are legal or not depends on a number of factors. VAWA by itself is a petition. VAWA does not keep people in status. However, if you have your VAWA concurrently with I-485, application for adjustment of status, that is what keeps you in status, not the VAWA. VAWA is just a petition. VAWA is similar to I-130. It is similar to I-140. It is a petition. So petition by itself does not keep people in status. So you may have VAWA pending and still be an undocumented alien and still be illegal alien. You may also have VAWA pending and be maintaining status. So it depends on whether the VAWA also have I-485 alongside with it. So that is what determines whether you are in status or not. If you have a pending I-485, you are in status. But if all you have is just the VAWA petition, you are still not maintaining legal status. The next question. Please, sir, is anyone... Oh, that's the same question. Good afternoon, doctor. The earliest appointment I can book is May 6, 2025. Is there any chance I could get an earlier appointment? Well, this is not a question I can answer over the podcast, but do you have the information of the person who sent the question?
No, that's just the person right there.
Okay, is there a way you can reach out to the person?
Tell them to send us a text to the number on the screen. Yeah.
Okay, we have a number displayed on our screen. If you look at your screen, you will see a number displayed there, 817-891-6655. Please send a text to that number and we will look at what we can do. We will see how we can accommodate you earlier. The truth of the matter is that my appointments are extremely tight, and I'm really overworking myself. In fact, I was just telling someone today that I really need to slow down. I'm really overworking myself. Last Sunday, I didn't even go to church. I was in the office working. Sometimes I stay in the office till 2 a.m. just because I'm trying to help a lot of people. But I'm not God. It is only God that can help everybody. I'm just trying my best. But I will try and see how we can accommodate you. Please move on to the next question, please. Sir, if someone still has a pending asylum immigration court case for an individual hearing, can my stepsister, a green card holder, file for me? Well, the truth of the matter is that your stepsister cannot file for you, a green card holder. I've stated it on this podcast several times. The way immigration law defines family is different from the way English dictionary defines family. For immigration law, there are different things that only a U.S. citizen can do and a permanent resident cannot do. One of them is filing for siblings, whether you're full sibling or half sister. Only a U.S. citizen can do that. Only a U.S. citizen can petition for parents. Permanent resident cannot do that. Only a U.S. citizen can petition for married children. Permanent resident cannot do that. Only a U.S. citizen can petition for fiancé. Permanent resident cannot do that. Now, assuming that your stepsister is a U.S. citizen, can he petition for you? Yes. Can the petition keep you in status? No. You're already in removal proceedings with a pending individual hearing. Can the petition be a relief for you in court? No. So even if your stepsister is a U.S. citizen, all these things are not possible. So you still have to find a way to present a different relief to the immigration judge. Your sister cannot help you in this case. Please move on to the next question. Good afternoon, doctor. Thanks to you and your team for the great work. Thank you too. God bless you guys more. Amen. Really had interesting conversation with you during the one-on-one last week. Oh, this was probably just a compliment. Thank you. Or is there a follow-up question? Okay. Thank you for the compliment. I appreciate it. Thank you. The next question. Good work, sir. Please, what options do I have as a Canadian with 2 U.S. citizen kids and wanting to move to the U.S. for them to start middle school? TN is not an option now. Thanks. Let me say this. A lot of people have the misconception that some countries are treated with preference when it comes to immigration. No. Every country is the same under the U.S. immigration law. There are only 2 areas where some countries may have an edge. One of them is what is called e-visa. E-visa is meant specifically for countries of certain countries, and those countries are listed in the Department of State website. Countries that are allowed to process e-visa. Many African countries are not included. Nigeria is not included. Those are areas where some countries have an advantage. The second area where some countries have an advantage is the North America Free Trade Agreement that is between the US, Canada, and Mexico. And that is the TN that you said is not an option. But in every other area, the same way that a Nigerian citizen will look for a way to keep himself or herself in legal status or to relocate to the U.S., that is the same way Canadian citizens will relocate to the U.S. In fact, in our office here, we have a lot of white Caucasian people from Canada, from the UK, from Germany, that are our clients. So don't assume that because, these are white people, therefore they have some privileges. No, they have to do the same thing. In fact, I have a white Caucasian Canadian citizen who was denied H-1B visa. So, no, you remember? Was denied H-1B visa. So it's not a big deal that being a Canadian citizen does not give you any privilege when it comes to immigration. The same way somebody who is from Nigeria, the same way somebody who is from Russia, the same way somebody who is from Kenya, we come to the US, you also have to do the same thing. So no preferential treatment. The only thing that will have given you the preferential treatment is the TN, which you already said is not an option in your case. So it's very unfortunate. The next question, okay, this is a comment. This is painful. Okay, maybe this person is commenting on the IRS issue. Yes, it's very, very painful. Very, very painful, because I've always advised people to do the right thing. And here we are now doing the right thing is also going to be problematic. So how do you continue to tell people to do the right thing? God will help us. The next question. Good afternoon, sir. Please, what options are available for an F1 student whose SEVIS has been terminated by ICE? The only thing you can do is to apply for reinstatement, but it depends on why it was terminated. As you probably have heard me today, a lot of people from last week and now, DHS have revoked student status for a lot of people, a lot of international students, even people who didn't participate in protest, people who didn't do anything wrong. They continue to revoke visas for everybody. And now anybody carrying South Sudan passport, it doesn't matter whether you are in the US or you're outside the US, US visa has been revoked for everyone with a South Sudan passport. So it's a problem that we really don't know how to fix. But if you know the reason, you can apply for reinstatement if it was your fault. For example, let me give you examples of people who can apply for reinstatement. Let's say your SEVIS was revoked because you register for less than the required minimum number of credit hours. Maybe you are required to register for a certain number of credit hours and you register for less, and because of that, they revoke your civics. Or maybe you didn't register for a semester. Maybe you have financial challenges and you stop registering or stop attending classes, and you are reported to ICE, and then your civics was revoked. So in those examples, you can apply for reinstatement. So in your reinstatement application, you will have to prepare a detailed affidavit stating why you stopped going to school, or stating why you did not register for required credit hours, and explaining that you have not otherwise violated your status, meaning that you have not worked illegally or you have not done anything else that can create a problem for you. So you can apply for reinstatement in such a situation. But if your service was terminated based on what is going on right now, honestly, that is a new area for all of us. We are in this together. We are learning it together. I have no idea how we are going to handle that, but we'll be seeking AILA's direction. AILA is American Immigration Lawyers Association, because this is a general problem. It's not a problem that is peculiar to one lawyer. So we will be meeting and deciding how to move forward, how to tackle it. But right now, at least two students have filed a lawsuit for challenging the DHS unlawful revocation of their civics and unlawful revocation of their F1 status. So we are going to see how the court will rule on that. But if your civics was revoked for a different reason, that especially if it is your fault, then you can apply for reinstatement. The next question, please. Okay. You just say good afternoon, sir. So what's the follow-up? Okay. My elder sister had a child outside wedlock and died just after putting to bed. Baby survived, and I've been caring for the child till now. The child is 18 years old now and still in home country. When I was doing my USA immigration process, I added the child as my child and did a follow to join process. The child is done with school and I like to bring her here to join me. What will I need to do? I'm a green card holder. Please, I had never filed for adoption for this child in my home country, and I'm told I can't do it now as she is 18 already. What would be your recommendation? Well, this is a very unfortunate situation, but unfortunately, you waited too long before asking questions. As you have correctly been told, you cannot bring this child unless you properly adopted the child. Because for you to bring a child to the US, the definition of a child under the Immigration and Nationality Act include biological children and adopted children. It does not include relatives. It does not include children of your siblings. So I don't see how you can bring this child in without adopting her. And of course, the child is already over the adoption age. Adoption must occur before the child turns 16. So since the child is already 18, you can no longer adopt this child. And I will not encourage you to lie to immigration that this child is your child, because if you do, what if at the end of the day they ask you to do DNA, and if the DNA proves that you are not the father, then the mother, I don't know if this person is a male or female. Well, if the DNA shows that you are not the parent, that may create additional problem for you. So I will not even allow you to go that route. So the only thing you can do, find other ways to bring this child to the US. Maybe since she's 18 already, apply for admission for her here, and then let her apply for student visa. If she's able to get it, then she comes in, and then you find a way to legalize her while she's already here. That would be my advice right now. And of course, if you are not successful with that, another thing would be maybe when she's of marriageable age, look for a spouse for her from here who will go and marry her and bring her in. You remember in the Bible, when it was time for Isaac to get married, Abraham sent his a senior servant to go back to his home country to go and look for a wife for Isaac. So you may look for a spouse for him when he's of marriageable age. For now, try the student visa. It's a 50-50 chance because student visa is a discretionary visa. But you can give it a try. There's no harm in trying. But don't go the route of claiming her as your child, because that can backfire and that can create additional problem. It may even affect your own ability to become a citizen. So that would not be a good thing to do. The next question, please. Hello, sir. Thanks in advance. I filed I-130 for my spouse back when I was LPR, and then later upgraded when I became a U.S. citizen. However, I did not hear anything from USCIS until now. What's your thought? Well, there's no timeline, so I don't even know if this is within or with outside processing time. We don't know if this spouse is in the U.S. or is outside the U.S. There are a lot of unknowns, but based on this fact, I'm suspecting that the spouse is outside the U.S. So in which case, you only file I-130 for right now. What you will do is go and check the processing time. If the case is outside the processing time, then you can file a service request. But if it is still within processing time, you just have to wait. There are some regional centers like maybe National Benefit Center. That place, you don't want to have your petition there. If your petition is there, the last time I checked, their processing time is about 40.
It's not even optional.
40 something. Is it 40, 48? Yeah, the last time we checked, it was 48 months. 48 months. That's how many years? That's almost 5 years. The processing time.
4 years.
4 years. That is 4 years, 48 months. It's ridiculous. But I will tell you, if you're already a U.S. citizen, go and talk to your congressman. Maybe they can do something. Because if your case is stuck at the National Benefit Center, there's really nothing you can do. Their processing time is 4 years. Oh,
52.
I was just told now that the processing time has increased to 52 months. Like I said, the last time I checked before now was 48 months. Now it's increased to 52 months. So it's even more than 4 years right now. So the only thing I can think of is go and talk to your congressman. Every congressman have a liaison office where they communicate with the DHS. So they have a back door that they communicate with the DHS. And sometimes it helps, sometimes it doesn't. But give it a try. Let your congressman know that this is your spouse and you want your spouse here. Request expedited processing. As I said, sometimes it works, sometimes it doesn't. So, but I will give it a try if I'm in your shoes. In the past, we used to seek ombudsman's help, but the office of the ombudsman has been cancelled by this administration. They have fired all the employees, so that office is no longer there. So there's really nothing much you can do. But
The spouse is here.
what?
The spouse is here, and it was filed July 28th, 2024, and upgraded March 2025. So just
If it was filed 2024, that's just last year.
Yeah.
That's just 1 year.
it depends on where it is too.
Yeah, so that's still normal. But More importantly, if your spouse is here, then you should have filed I-485 along with it, filed employment authorization along with it, so that even file travel document if you need to travel. So that should not be an issue. But anything that is under 1 year, you can't even. There's nothing you can do. Even there's nothing the congressman can do. So this is not eligible for that kind of delay. This does not qualify for delay right now. So it's not one of the cases that you can even consider mandamus, which is the last resort. But for you to consider mandamus, at least for me, the case must have been pending for maybe 2-3 years, usually after interview. But in this case, it is still normal. Everything is still normal.
I'm going to show it from the phone because it's kind of long, but this is the next one.
Okay. The next question. Dear Dr. Asekun, I hope this message finds you well. I'm currently residing in Dallas, Texas. I recently married a U.S. citizen, and she filed a petition on my behalf. We submitted all the necessary forms for my adjustment of status. We were both scheduled for biometrics appointment, which we completed. However, my wife's appointment notice included an Walsh Act memo. It has now been 3 months since our biometrics, but we have not received any update from USCIS. I also haven't received my work permit yet. Could you kindly share your insight or advice based on your experience with similar cases? Thank you for the question. This is a very, very interesting question, and it's important that people listen to this. Excuse me. For those who don't understand, they will be wondering, what is Walsh? Walsh is an act, is a law that was passed and named after a child that was abducted by a predator. The father really put a lot of pressure on the Congress to change the law, and then Congress passed a law. They named that law after Walsh. The father's name is John Walsh. For those who normally watch this program, is it 10 most fugitive, something fugitive, 10 most wanted list or something?
The FBI most wanted?
Yeah, the FBI most wanted. That is the father. That is Walsh's father. That is John Walsh. Is the one that started that program. Yeah, to make sure that they track all the fugitives wherever they may be in the world. He's the one that started that program. So his name is John Walsh, but the son's name is Walsh, that was killed by this predator. Now, this law deals with child molestation. Anytime somebody is convicted of child-related offenses, child molestation, child trafficking, child pornography, any sexual act against a child, against a minor, so that person cannot get any benefit under the United States immigration law. So if someone who has been convicted of an Walsh Act is the one you are married to, you cannot get green card in the United States. That is the law. So the petition that this person filed for you, that petition cannot be approved. That is the law. That is what Walsh Act is. Anytime you see immigration requesting the petitioner, I'm not talking about the beneficiary now. Anytime you see the immigration asking the petitioner to go for biometrics, that is a sign of Walsh Act. That is a sign of Walsh Act. Generally and usually, petitioner do not need to go for biometrics. The petitioner is already a U.S. citizen. They don't go for fingerprinting. It is only beneficiary that go for fingerprinting. So anytime USCIS asks your petitioner to go for fingerprinting, that is a sign that that person has been convicted of Walsh Act. And of course, remember that USCIS, they don't rely on the state background. They use FBI background check. And for FBI background check, even if the offense is expunged, they will still see it. So anytime they ask the petitioner to go for fingerprinting, that is a sign of Walsh. And in this particular case, they already provided you that information by giving you the Walsh memo. So what it simply means is that your petition is not approvable. That is the simple truth. Next question, please. Okay, next question. Good morning, sir. I submitted my petition for the American widower or special immigrant 2 years ago. I did my biometrics 3 months after, but I haven't heard from USCIS since then. 2 years ago. Can you help me check the processing time for I-360 now?
Sorry, which one was it? It's not VAWA, is it? Or is it?
Well, it didn't indicate, but I'm assuming that is the widower.
A widower?
Well, just check everything, because if the person didn't indicate whether... Let me say this. That form I-360 is used for multiple things. The same form is used for religious workers. The same form is used for VAWA petition. The same form is used for widow and widower. The same form is used for SIJ, Special Immigrant Juvenile. I've mentioned religious worker. I mean, the form is used for multiple things. So
It's kind of hard.
if you just look at the processing time and
8.5 to 40 something, depending on what, 42, depending on
between the processing time is between 8 months and 42 months. And of course, 42 months is almost 3 years. So we don't know which of the forms your category fall into. If you can clarify it, can you scroll down and see if this person has clarified which of them?
It was by text.
Oh, okay. Yeah, if you can clarify it, but whichever case it is, the processing time is between 8 months and 42 months. So it depends on which one yours fall into. The next question. Sir, please can a first-time offender charged with public intoxication with a permanent resident green card be denied entry back into the U.S.? Yes, you can be denied entry if you are convicted, even though it's a public intoxication. The issue here is that for permanent resident, it is something called what? It's not good moral character. The language just disappeared from my head now.
Is it not good? I thought it was good moral character.
No, that's not the word. Good moral character is for citizenship.
Uh-huh.
What's the other one for cancellation of removal? It actually means the same thing, but I'm just trying to remember the
I thought cancellation was the same thing.
oh. Anyway, if I remember the word, the word that just disappeared from my head right now. Yeah, you can actually be charged as an arriving alien once you have a criminal record, especially under this administration. I will not travel. I will not. Coming back, you can be detained and charged as an arriving alien. So if you are charged with an arriving alien, you'll be required to see an immigration judge. They will admit you in, but they will detain you and place you in removal proceedings. So That is the risk. I will not do it if I'm in your shoes. Is the part 2 from the same person?
Yes.
Okay. I don't have my social security. No, it cannot be from the same person. That one is a permanent resident. So
Oh,
this
yeah,
must be from a different person.
it is. No, it is.
No, I took it from the text.
Questions or,
Oh, is this yours?
that one was mine, yeah.
This one is saying I don't have my social security number. So it cannot be a permanent resident cannot be without a social security. Definitely it cannot be the same person. It must be a different question from a different
I posted
person.
this one and it was on the message. I posted it, it's here. Let me look.
How can he be a green card holder at the same time say I don't have my social security number? I even petition for an expedition. They sent a letter of prima facie determination. I called 1 month ago to.
The part 2 is from the VAWA or the I-360. Not that one, no. Wait.
Go back to the question that was talking about American person. So the person just assumed that I will know that it is VAWA. That form is used for multiple things.
Oh, maybe I skipped it. Let me see.
Yeah,
Okay,
that-
this is
yes.
this is the this is the first question.
Yeah, the first part.
The first part of the question.
You
Okay,
started to-
let me go back let me just read this first part, then you go to the next one so that I can handle it together. Good morning, sir. I submitted my petition for the American widower or special immigrant 2 years ago. I did my biometric 3 months after, but I haven't heard from USCIS since then. Move to the part 2, please. I don't have my social security number or EAD. I even petitioned for an expedition. They sent a letter of prima facie determination. I called 1 month ago to ask why I haven't gotten any of my documents. USCIS told me that my file and case were okay, and they said I should write a petition for the delay. My question is, what should we go ahead and write the petition? Okay. I hope writing the petition will not affect my application. What is your advice on this, sir? Thank you. Okay. This is a very good question because this is one of the confusions that people have. Based on this question, this person has a pending VAWA that is based on I-360. VAWA does not give you employment authorization. I-360 does not give you employment authorization. So if you are waiting for employment authorization, you are not going to get one. You are not going to get one until the VAWA is approved. And even when the VAWA is approved, sometimes you may get it, sometimes you may not. Because what you will get mainly is the approval notice. However, if you are going to request employment authorization, you need to file I-485. You need to file I-485 application to register permanent resident. Then you need to file I-765, which is employment authorization. Employment authorization is usually based on I-485. It is not based on the petition. I-360 is just the petition itself, so it does not give you any work authorization. So you have to file I-485. I-485 is the application that authorizes employment. So once you have a pending I-485, then you can apply for employment authorization. But if all you have pending is just I-360, you are not eligible for employment authorization. So you will need to go and file I-485 and then apply for employment authorization. You can do it concurrently. You can do both of them simultaneously. If you are going to do it, make sure you include a copy of the receipt notice for the I-360 to show that you have a pending I-360. Otherwise, they will not accept your application for permanent residence. Next question, please. This one, okay. Sir, please can a first-time offender charged with public... No, I already answered this.
You did? Okay.
Yeah.
No, you,
Yeah, I already did.
Somebody's grading you. This one.
Okay. This one also seems to have a lot of parts because it says part 1. And the next one I see is part 3. So where is part 2?
No, that part 3 is from the other lady from the VAWA.
yeah.
Okay. Good morning, sir. God bless you, sir, for the good job you are doing. Thank you. I'm from Nigeria, married to SA lady. What does SA mean? Could it be South Africa?
I was thinking.
Maybe South Africa. Okay, let me just continue. I'm from Nigeria, married to SA lady. I got my 10-year green card on November 2024. My wife traveled to their country.
December.
Okay, traveled to their country December, came back this January and told me that she want to go back home permanently, that she want us to divorce. And I tried all I could do, but all proved abortive.
I think that's it.
No.
No.
Do you want me to read it on this cell phone? Maybe it will be much easier. All this part is a little confusing. Thank you. So this is all the questions. Okay. Good morning, sir. Bless you. God bless you, sir, for the good job you are doing. Thank you. I'm from Nigeria, married to SA lady. I'm assuming this is South Africa. I got my 10-year green card on November 2024. My wife traveled to their country December, came back this January and told me that she wants to go back home permanently, that she wants us to divorce. I tried all I could do, but all proved abortive. Sir, I need your advice. Hope if she divorces me, I will not get problem in getting my citizenship, sir. Also, she said the divorce will take up to 6 months before we can get the divorce decree because we did the wedding in Abuja. Thanks, sir. God bless you. There's a lot of misconception here. First and foremost, if you are going to divorce, you can file the divorce in the country and the state where you live. The fact that you got married in Abuja, Nigeria, does not mean you have to do the divorce in Abuja. If you are living in the US here, the divorce can be filed in the state where you live. It does not matter where the marriage took place. Now, talking about getting divorced, considering the fact that you just got your green card late last year. You see, immigration law is very clear. The law does not say that a marriage must work because they recognize the fact that two people do have disagreement. Two people do have issues. The law does not require that a marriage must work. What the law requires is that the marriage must have been entered into in good faith at the time of marriage. So what you will need to do is to gather evidence that at the time you enter into this marriage, it was not because of papers. It was because you intended to live together as husband and wife for the rest of your life. However, if the marriage failed along the way, then that is something that both of you cannot control. So for as long as you are able to prove to USCIS that your marriage was entered into in good faith, you will still be able to get your citizenship. However, did you not have a conversation about where you will live before or after marriage? But of course, things change. Maybe she has a reason for trying to relocate back to her home country. But what you need to do, gather evidence from inception, from the day you met up till the date you got your green card, and whatever you have together after the date of your green card. Gather your evidence together. If the marriage does not work, there's nothing you can do about that. You will still get your citizenship. The only thing is you need to prove that your marriage was entered into in good faith. The next question, please. This one. Yeah. Whenever you have the longer one, let me just read it from the cell phone so that we avoid this part 1, part 2. Yeah. Good afternoon, the law. Please, if you are on removal and you have a property on mortgage in the US, what happens to the property when you are deported? Well, you remember that the property and your deportation, they are two separate things. People who don't live here, there are people who don't live in the United States who have properties in the US. I remember during the recession in 2008, 2009, a lot of my friends who are in Nigeria, never been to the US, they sent money for me to help them purchase properties because properties were so cheap at the time that, you are getting almost 40, 50, 60% value for what you are buying. So we purchase a lot of properties on behalf of people. What do we do with those properties? We fix it and rented it out. And of course, they were collecting their rent. So having a property, being deported, they are two separate things. So if you own your properties, if you don't have mortgage on them, rent it out and continue getting your rent. Or if you choose to sell it, if you want to cash out your money, you can sell it. Even if you have mortgage, you can still rent it out, use the rent to pay the mortgage and build additional equity. If you don't want to rent it, you can sell it and cash out your equity. So, contact us privately. I will give you more information on what you can do, but they are two separate things. Your deportation does not affect your ownership of the property. You own it, There's nothing anybody can do about that. The next question, please. What document will my mom need for B1, B2 visa in Nigeria? She isn't, she isn't or she is?
I think she is.
She is supposed to be she is. She is 77 years old. She has never worked. She's been to USA 3 times, never overstayed a visit. I'm a USA citizen. To be honest with you, the fact that you are a USA citizen may actually lead to your mom being denied visa under this current administration. So that does not even help you. But to answer your question directly, there is really no documentation required other than send her a letter of invitation. In that letter of invitation, include Form I-134. Form I-134, Affidavit of Support for Non-Resident. Include that in it. And again, in your letter of invitation, state very clearly that you are the one that will be responsible for the cost of boarding, feeding, and even traveling to the US. State further in your form that as a US citizen, in your letter of invitation, as a US citizen, you will have loved to petition for your parent, but your parent probably does not like living here. That is why you are not, because they can deny her visa and tell her that, tell your son to file a petition on your behalf. Of course, you can also do that. You can file a petition on your behalf, but if you just want her to get a visiting visa, write a very detailed letter of invitation. State clearly that you are the one that will be responsible for the cost of transportation, boarding, feeding, and all the expenses. Also include Form I-134, which will show that you have the financial capacity to bring her here and to finance her trip. The next question, please.
Oh yeah, she corrected herself. She said, she is 77 years old.
Okay, yeah, we already answered that, yeah.
Someone is saying, thank you, sir, for your good work.
Thank you. Now, before I go into the next question, I want to repeat for the benefit of those who are just joining us, for the benefit of those who didn't join us from the beginning. I have a very, very, while I'm not a carrier of bad news, I have a news that is not very pleasant. In fact, a news that devastated me, a news that affected my mood. I'm somebody that is really affected by what people do. But in this case, this administration, they pushed me to the wall. In one of my recent podcasts, I stated correctly that everyone making money in the United States, they are required to file taxes. Whether you live here, you don't live here, whether you have Social Security, you don't have Social Security, for as long as you are making money in the United States, the law requires that you must file taxes. Even for those who don't live here, their tax return, the form is called Form 1040NR, non-resident. It is the requirement of the law. And I went further to explain that when people file taxes, if they have to apply for cancellation of removal in the future, it will be additional evidence of good moral character. It will be additional evidence of good moral character. When you lack good moral character, the application for cancellation of removal is likely going to be denied. So I encourage people to file taxes as required by law. Unfortunately, the DHS, they have been putting pressure on IRS, asking IRS to provide information of undocumented people, information of people that are here unlawfully, information of people that are overstay, information of people filing taxes but who don't have Social Security number, information of people who apply for ITIN. They've been putting pressure. The leadership of IRS have been resisting it, but unfortunately, yesterday, the IRS succumbed to the pressure. And now, the IRS have entered into an agreement with DHS to provide information of people that are not documented. This is a very sad day for this country. In fact, the leadership of the IRS was so angry, 3 of them resigned in anger. 3 of the leadership of the IRS. Okay, they are just showing me another article now on CNN saying acting IRS commissioner resigned after agency reaches data sharing deal with immigration authorities. This was, it was when it happened yesterday. So, we are in a very uncharted territory. I don't even know how to express my feeling. How do you advise people to do the right thing, and then the government is making it look as if they are making mistake by following the law, by doing the right thing? I'm in a position now where I have to apologize for telling people to do the right thing. I stated it at the beginning of the podcast, and I'm restating it now for the benefit of those who are just joining us. If you listen to my podcast and you follow that advice and you file your taxes based on the advice that I gave you, if anything happened to you, immigration-wise, please contact our office. I promise to defend you free of charge. A lot of people after that podcast reach out to us in this office asking questions. How do we go about it? How do we file these taxes? What are we supposed to do? Can you guide us on how to do it? And we did. So what do we tell those people now if they get into trouble for doing the right thing, for following the law? This is a very sad day in my over 3 decades of legal practice, I never knew that I would be in a position where I would be forced to apologize for doing the right thing, apologize for giving the right advice. But I am now. If you have followed my advice and you get into immigration trouble, please contact this office. I promise we will defend you for free. I don't know how this is going to end, but like I said, a lot of, oh, this is another resignation. Okay.
That's her, the one that you mentioned earlier.
Oh, okay. Yeah, a lot of leadership of the IRS, they are resigning in anger. The truth of the matter is that even the US government will lose money. It is taxpayers' money that we use to develop this country. Whatever this administration is doing, all the money they are spending, they are from taxpayers. So if you are telling people to file taxes and they are following your rules, and you are now using it against them, how does that even make sense? Those of us who are American citizens, those of us who are legal, when we file taxes, we get money back. But these people that are unlawful, they are the ones that actually pay the more. They are the ones that pay more taxes because many of them are not able to get tax refund. So it is their money that the government is using. There was a year that IRS published list of unclaimed tax refunds because people are not able to claim it because they don't have legal status. This is the money that this country uses to execute or implement all their policies. So how do you now discourage people from filing taxes? Because this is definitely going to discourage people. If I'm not lawful here, and I already know that DHS is going to get my information through IRS, will I file taxes? No, I'm not going to. So how does this make sense? We know that we have seen a lot of other things that doesn't make sense. I mean, for those who invest in stock market, I don't need to tell you what is going on, but that's a topic for another day. But the reason I'm bringing it up, for those who didn't join us from the beginning, I want you to know, if you are one of those people who followed my advice, all you need to do is just to show me the evidence that you followed the advice after listening to my podcast. I guarantee you, if anything happens, I will defend you free of charge. So I just wanted to restate that before we continue. Please, the next question. Okay. Next question. Please, sir, I want to know if you are not under parole program and apply for asylum, did the pause affecting me from getting my work permit? No, it doesn't. It doesn't. If you are eligible, just check the clock. If it is affirmative asylum, you have to wait 150 days. If you are already in removal proceedings, you have to wait 180 days. Excuse me. So once you are eligible, you can apply. You can apply for employment authorization. The pause does not affect it. They are still processing asylum, and we are still attending interviews. We are still getting work authorization. It does not affect it. Basically, when it comes to asylum, those who are affected are the refugees, those who are from outside, not people that are already inside the U.S. The next question. Good day, sir. My husband got his citizenship through marriage and now divorced in December 2022. When is the right time to start the application process for you? We got married November 2024. November to now is already like December, January, February, March, April. Yeah, you can file now. There's really no waiting time. You can go ahead and submit your application. There's no waiting time. You can do that now. Next question, please. Thanks for all you do, sir. Please, is it advisable for a green card holder to file for her spouse who is already in the U.S. but out of status? No, it is not advisable, because if your spouse is already out of status, the application for green card will be denied. And under this administration, once it is denied, they are going to place her in removal proceedings. So it's not even advisable. Don't even risk it. I will not do it. Just be a little patient. Let us stay low and not get ourselves into any problem or anything that can lead to immigration arrest or anything. And then subsequently, once you are eligible for citizenship, just apply and get it, and then you can petition for her. The only thing you should do right now is get married, so that that will be in record. In case she gets into trouble, it will not be that she got married after she was already in removal proceedings. So that's all you need to do. But it is not advisable to file for someone who is out of status. Only a U.S. citizen can file for somebody who is out of status. The next question. No, I already answered that one. Okay. Hi, I got 212H waiver for a deportable crime. Okay, CIMT was what I was trying to remember. Moral turpitude.
Okay, I saw that, but I was like, I don't think that's what he's talking about.
Yeah, moral turpitude is what I was trying to say. Yeah, that was the question about the green card holder who said he was convicted of DWI. Yes. Yeah, crime involving moral turpitude. Yeah, that's CIMT. That's what I was trying to remember. That's the language. Yeah, I got 212H waiver for a deportable CIMT and adjusted to LPR time to renew. Time to renew my green card is it safe or can I wait? Yeah, it is safe. You can approve. You can go ahead. Your crime has already been waived. This 212H has already waived it. You can apply. However, the fact that you apply does not mean that you are eligible for citizenship. You have to get that very clear, because I don't know the detail of the criminal activities, but what the 212H granted was a waiver for that offense for the purpose of your permanent resident card. It does not mean that you will be eligible for citizenship. I've had a client who got a 212H waiver. Then, when it was time for citizenship, immigration still denied the citizenship application on the ground that the main offense was an aggravated offense. Even though this was a non-violent offense, it has to do with exchange of check. But because the amount involved was more than 10,000, and under the aggravated felonies statute, any offense that involves an amount of $10,000 and above is considered aggravated felony. So because of that, they denied the citizenship on the ground that he is not eligible for citizenship, despite the fact that the 212H waiver has been granted. But again, every case is different. I've also had similar situation. Another client granted 212H waiver, applied for citizenship subsequently. Immigration denied it, claiming that he was not eligible for citizenship. I disagree with them. I went to court. We went from district court to the court of appeal. At the end of the day, the client was successful, and the client is now a U.S. citizen. So every case is different. Immigration is not a one-cap-fits-all. But your question, can you apply? Yes, you can apply. Even if they deny the citizenship, they cannot place you in removal proceedings, because the 212H has already been granted. That already eliminated the issue of being removed in the U.S. Just don't get involved with any other thing that can come up as new offense. For as long as you don't have that, I will go ahead and apply for the citizenship. Worst case scenario, they will deny it. If they deny it, you still have an opportunity to challenge it. You can request a hearing. Even if they deny the hearing, you can still go to district court to ask the district court to look into it to see whether immigration was right or wrong. So all this, because it does not put your green card at risk, I will go ahead and apply. Next question, please. Okay. Thanks, sir. A friend's wife and 14-year-old daughter arrived U.S. less than month, she's not ready to go back. Please, sir, what can she do now before her 6-month validity expire? Her husband is still pending asylum. Well, this is not the kind of question we can answer in this type of podcast, because this is an open-ended question. This will require me to go through the entire immigration relief, non-immigrant reliefs, immigrant relief, employment-based, family-based, humanitarian consideration. This is like opening a blank check. This is not the kind of question we can answer here. I will request that this person should request maybe a one-on-one consultation. It's too open. I cannot deal with this question in the next 30 minutes. The next question, please. As a USA citizen, but let me say this before I go into that into the next question. Let me say this. Like I said, there are a lot of unknown from this person. This is an open question, but let me quickly run over the benefits that are available. For somebody who is still maintaining legal status, you still have the opportunity to change your status from one non-immigrant to another. That is, you can change from B1, B2, you can change to maybe F1, you can change to M1, you can change to maybe R if you are eligible. You can change to H, but H is currently not available. You can even apply directly for EB visa, depending on your background. I mean, it depends on your educational background, depending on your field. There are so many things. In fact, it doesn't make sense attempting to answer this question here, because there's so many things that I would need to ask, I will need to know, I will need to advise. I think the best thing is just do a consultation appointment. Not necessarily with me. You can do it with any other lawyer, and they will go over your options with you. Next question, please. The next question. As a USA citizen, can I petition for my niece? No. Capital no. I've said it over and over. The way immigration defines family is different from the way English dictionary defines family. Under immigration law, your niece is not part of your family. Under the United States immigration law, family of a U.S. citizen is limited to parents, spouses, that is husband or wife, minor children under 21. That is it, nothing else. Even your own biological child who is over 21 is considered extended family member. Your own siblings under immigration law, they are not immediate family. So a U.S. citizen can petition for immediate family members, parents, spouses, minor children under 21. A U.S. citizen can petition for extended family member, which is limited to siblings, children over 21 unmarried, children over 21 married, and of course, fiancé. That is it. A U.S. citizen cannot petition for grandparents. They cannot petition for nieces. They cannot petition for nephews. Those are not considered part of the family. Next question, please. So there is a problem for people that had already filed their tax with ITIN. I mean people that have overstayed their visa. This is a scary period. Thanks for your enlightenment and courage always. Oh, thank you too. My son will be, the next question. My son will be 21 in December. He was born in the United States. Please, when can he start filing for me? He can file for you on the very day that he turned 21. So if you want to make it speedy, maybe 2 weeks before his 21st birthday, start putting the documents together. Go ahead and do the medical. Have everything ready. The day he turns 21, send in your application. There's no way. You don't need to wait extra one more day. Next question, please. Please indicate where we are going to stop because I realize it's already 1:20. Okay, next question. Sir, part 4 of your immigration update, you mentioned. Huh?
The fourth,
Yeah, I understand what you're saying. Yeah. Part 4 of your immigration update, you mentioned joining ASAP can fast track EAD. I mean, he meant EAD and SSN for asylum seekers. I'm already a member. ASAP, should I still wait?
should I still wait here? No, sorry. 150 days.
Okay, yeah, should I still wait 150 days before applying for my work permit through Form I-765, then add my ASAP membership ID? Thank you. Oh, yes, you still have to wait because the 150 date, that is a statutory requirement. It is required by law. The ASAP membership, that is a lawsuit settlement. The ASAP filed a lawsuit against immigration regarding delay in the issuance of employment authorization, and they now reach a settlement where immigration promised that any member of ASAP who apply for employment authorization the first time, they will give it expedited processing. So the purpose of the ASAP membership is expedited processing, but the purpose of the 150 days, those ones are statutory requirement. Yes, you still have to wait 150 days, but as soon as it is 150 days, apply and attach evidence of your ASAP membership. You should get your employment authorization approved within 30 days. Next question, please. Hello, team. I have a question. Please, can a Canadian citizen who gets an H-1B visa through a USA employer file for the spouse who is currently undocumented in the US? Though, is it a continuation? Can you please look? Look, I've told you to all. Let me read it from the.
This is the one that was on the paper that you couldn't read.
Oh, okay. So is this the part 2?
Yes.
Okay, the spouse came in legally as a student, but status got expired, or the Canadian citizen needs to get a green card first before filing for spouse. Please advise. Well, none of the above. One, you cannot include your spouse who is already out of status. Two, even if you get your green card, you still cannot fix your spouse status because a green card holder cannot help someone who is already out of status. So you have to get your own green card first, become a citizen first, and then file for your spouse. It is very unfortunate, but that is the reality. But what I will do if I'm in your shoes, since you are a Canadian citizen, why not get your spouse Canadian residency or Canadian citizenship? Because if you do, then your spouse can step out and go back to Canada and do consular processing. The worst case scenario, it will be your spouse will be affected by the 3 and 10-year bar. If your spouse is affected by the 3-year bar, 3 years is not a long time. You can always go back in and out of Canada and US and visit each other. But if your spouse is affected by the 10-year rule, when you get your own green card, you can actually petition from your husband from outside the US and then request a waiver of unlawful presence. That is your only option. But right now, you cannot get H4 for your spouse and you cannot file for your spouse. You cannot include your spouse in the green card application. It will be denied. Next question, please. Hello, doctor. Thanks for all you do. I'm a 10-year permanent resident holder since 2019. I've also applied for my citizenship this April 2025. My ex-husband does not want to complete. Please move on.
The divorce.
So how is that relevant to the?
She wants to know if that's not going to affect her.
Do you have it in the?
I don't
Which
know
one?
which one.
Sorry, let me see. Is it me? Oh, that's me.
It's a 10-year permanent resident. She applied for citizenship.
Yes, that's me.
Maybe she,
I think.
no, it wasn't.
Today, okay.
She just wants to know that the fact that she's still married and she travels without the husband, if that's going to affect her, because he doesn't want to complete the divorce papers. It's mine.
Yeah, you're right.
Okay. Well, it depends on a number of factors. Can you go back to the question again? Okay. I'm a 10-year permanent resident holder since 2019. I've also applied for my citizenship this April 2025. My ex-husband does not want to complete the divorce. Well, number one, the divorce has nothing to do with your citizenship application since you are applying based on 5-year you are applying based on having been a permanent resident for 5 years. However, there's a lot of issues that can come up. Number one, it depends on the state where you live. For example, in Texas, Texas does not recognize legal separation. In Texas, you are either married or you are divorced. So if you are completing your application for naturalization, if they ask for your marital status, you have to indicate that you are married. That is the law in Texas. There is no third option. You can't be legally separated. In Texas, you are either married or you are not married. So one, it depends on the law of the state where you are, because if the law of the state where you are does not allow separation in your citizenship application, you have to indicate that you are married. And if you are married, of course, during citizenship, they can always ask questions about your spouse, even though your spouse is not required to attend the interview with you because your application is based on the 5-year permanent residency. However, the officer may go into the bona fide of your marriage. They can go back to start asking questions from the time of your marriage. Again, it depends on the state where you live. In Texas, I'm using Texas as an example because that is the state where I live. In Texas, your husband does not need to sign divorce papers. Either party can file for divorce, and you can get divorced in Texas without your husband signing. Number one, when you file the divorce in Texas, I'm using Texas as an example, you can get a constable to serve your husband. The constable can serve him the divorce document. Even if he refuses to sign for it, it is the constable that will come back and file a report, return of service, and tell the court that they attempted to serve this person. Secondly, assuming that you have been separated and you don't even know where this person lives, in Texas, you are allowed to do publication or citation, in which case they will publish it at the courthouse that, oh, this person has filed for divorce, and they will give your husband certain number of period to appear. If he doesn't appear, the court will go ahead and grant you the divorce. It also depends on another factor. This marriage, I don't know whether you have minor children between you and your husband. Assuming that you have minor children, the court, even if your husband is not, you cannot locate him or the bailiff cannot locate him, the court will appoint what is called guardian ad litem. The court will appoint another lawyer to represent the interest of those children. It doesn't matter whether the children are U.S. citizens or not. For as long as they are here, the court will appoint a guardian ad litem, and then that guardian ad litem will act as a lawyer for the child, not your husband, but for the child. And the court will still grant the divorce after everything has been done. But for immigration purpose, find out the law in the state where you live, because if the law if your state law does not recognize separation, then you have to indicate in your application for naturalization that you are still married. And whether or not you do that, questions can go into your marriage. Questions during citizenship can go back to the issue of your marriage, relationship, and all of that. Going back to the question of traveling, again, the same thing affects your ability to travel, because if you are still married, if you travel and you are coming back, immigration can still ask you questions about your spouse. It doesn't mean that they are going to deny you entry, but they can ask questions. They can ask questions to be sure that you didn't get the green card solely based on fraudulent marriage. So they can ask questions. And for as long as you remain married, they can call your husband too to ask questions. So those are the risks of traveling when you are not divorced. But the risk is there, but it is doable. Next question, please.
Okay, there was a second part to this one. It was just this part right here. Hey, Chris, can I still travel to? Oh, okay.
You already answered that.
Yes, okay, that's the next one.
Okay, sir. Good day. Please, I'm new here. I want to ask, can someone file in for me, although it's overdue for citizenship, but just having only a PR? If not, how do we go about it? Well, I think I've answered a similar question today. If you are new and you are still maintaining status, if your I-94 has not expired, yes, a permanent resident can file for you. You can go ahead and do it now. There's really no waiting time if you are married. But if your I-94 has already expired, then you should not do it, because if you file, one, it will be denied, and two, if it is denied, they will place you in removal proceedings, and you don't want that. Since he's already eligible for citizenship, let him go ahead and apply for his citizenship. You can go ahead and get married so that when he is applying for citizenship, he will list you as his spouse. And of course, that will make things easier for you whenever he petitions for you. But he should not do it as a permanent resident if you are out of status, if your I-94 has expired. Next question, please. Hello, sir. Does a beneficiary's son of a green card holder living in US need an extension of visa while waiting for interview from local office after being done with benefit center? What is this person saying? I have no idea. What is benefit center?
Does a beneficiary?
The National Benefit Center?
It says the person is here.
Oh, okay.
Does
So
a
the
beneficiary?
The I-130 is pending at the National Benefit Center. And he wants to know if while the I-130 is pending, he needs to file an extension of his visa while waiting for interview.
Who is the petitioner? Who is petitioning for this person? Is the petitioner a permanent resident, or is the petitioner a US citizen?
Beneficiary of a
So, because if you look at the beginning of the question, it says derivative. So that means that the person who petitioned for her to get her own green card is the same person petitioning for the son.
That is a derivative.
I think I saw something.
Does a beneficiary's son
of a green card.
of a green card holder living in the United States need an extension of the visa while waiting for the interview from the local office? So I'm thinking the I-130 has been approved.
So what is pending? I-485?
The I-40.
Because if you have a pending I-485, you can't even do extension of visa. Once you put in your I-485, that stops the clock. You cannot be out of status while the I-485 is pending. So you don't need an extension of visa. I hope that is what the question is asking, because the question is not very clear, but I hope that is what the question is asking. So go to the next question. If the person who asked the question is still there, I can clarify it, because there are so many things that I don't understand from the question. The next question. I had a consultation with you and I have prepared all the information you asked me for. I've been calling for 3 days and I'm unable to reach anyone in your office and the next available date is far. That would be strange under our new system. Maybe, okay, let me tell you this. Sometimes last month we upgraded our phone system. So right now, to reach us, you can dial any of these numbers: 817-274-1144. Again, 817-274-1144. The other number is 817-274-1844. 817-274-1844. So we upgraded our system because to make things easy, to make it much easier for people to reach us. So you can call any of those two numbers. You can also send an email. I'm sure when you consulted, you probably received an email confirmation of the appointment. So you can use that email in there, info@olufiade.com, to send an email, and I'm sure somebody will reach out to you. The next question. Hello, sir. Can someone pause not to file his taxes due to what IRS has said regarding collecting people's information? Oh yes, that's what I said. If I'm yet to file taxes and I know that I'm undocumented, I will not file taxes at this time. The good thing is that under IRS law, you can file individual personal tax return up to 3 years backward. So we are currently filing 2024 taxes. You can still file in this year, you can still file 2024, 2023, 2022. So for me, if I'm in your shoes right now, if I don't have papers, I will pause on filing any taxes for now. That is why I said that the government is going to lose money at the end of the day, because why would I want to go and create a problem for myself? Why would I want to file taxes and then somebody will show up at my door the following day or the following week? I'm not going to do that.
But then it's going to be either a problem with IRS or a problem with immigration.
Well, it's going to be, but at the same time, it will be. I think it's going to be on a case-by-case basis, the immigration judge, because if you have to prove good moral character and the judge is saying that, or maybe DHS lawyer is saying that you didn't file taxes, I will ask, how do you expect me to file taxes when I know that if I file it, you are going to arrest me? How do you expect me to file taxes? You can't use that as lack of good moral character. I mean, that is simply protecting myself. That's not, is it even legal for IRS to be providing information to DHS? It is not. So in law, you cannot, there is a legal maxim that says that out of an illegal transaction, there is no cause of action. So if the DHS action is not legal, you cannot use it against me to show that I don't have good moral character. That will be a matter for litigation. You just need to have a good lawyer. But I will not file taxes, honestly. Under this condition, I will not. And I don't care. The government may be listening to me now, even though I'm not affected, but you can accuse me of encouraging people not to file. Yes, I will encourage them not to file because you are also doing illegal things. You are not following the law. The painful part is that between last week and now, last week I mentioned that the president signed an executive order directing the Attorney General to go after some lawyers. Do you know they have actually started implementing it? In fact, a lawyer was coming back from vacation. Let me show it to you. It was, how can I show this on the screen? If you can help me show it on screen, just for viewers to see the headline. It's from the Detroit News. Lawyer for UN protester detained at airport after spring break trip with family. Yeah, even lawyers, they are detaining them now at the airport, coming back in. They are seizing their cell phone. Just the headline.
I don't think it will focus on.
No, it's too close. Okay, we should. Are they able to read it? Read it out if you can.
Lawyer for UN protester detained at airport after spring break trip with family.
Yeah, you can show your lawyer's face. I think.
No, that's Donald Trump.
Oh, that's it. Oh, okay. Yeah. Okay. Yeah, there have been series of report of. They are able to read it. Okay. Yeah, there have been series of report of lawyers being detained, being embarrassed at airport, especially when people make international travel. I'm going to continue making international travel. If you want to meet me at the airport, we meet at the airport. It's too late for you. I'm already a citizen. There's nothing you can do about that. We'll fight every other thing in court. The next question, please.
Okay, there you go. It's on the screen.
Okay. Under what condition can an order of removal, ordered removed immigrant file tax? Is that what? Yeah, under what condition can an ordered removed immigrant file tax?
I mean, unless you have like a green card.
I will not even, if you have been ordered removed, you should be the last person to file taxes, because under this arrangement, I guarantee you are going to be picked up. I will not. If I'm in this situation, I will not file taxes at all.
What if they have a green card?
You can't be ordered removed and have green card at the same time. If you do, is either the green card was not obtained properly, or the order of removal, I mean, maybe it was in absentia, you didn't know about it, in which case you can file your taxes. If they arrest you, they will take you back to immigration court. You file a motion to reopen. Yeah, if you already have a green card, you can file it. But if you have been ordered removed, honestly, under this current situation, if I'm in your shoes, I'm telling you what I will do. I will not file it under this current situation. The next question. Oh, it's just a comment. God bless you, Dr. Olu. Thank you. Amen. The next question. Please, sir, what can someone on F1 who has filed EB2NIW pending, has advanced degree, who is going to community college to maintain status, travel to home country for restamping, can they do it in Canada? Well, it's risky, because sometimes Canada, the U.S. Embassy in Canada can tell you to go back to your home country to go and do it, that they don't have enough information about you. You are not a citizen of Canada. I've seen this happen, and I've also seen them grant it. So it's risky. So it's a 50-50 situation. What I'm going to tell you in this situation is that except it is really, really extremely necessary, I won't even travel under this situation that you presented. I will not, because the truth of the matter is that you already filed the NIW. That is already an immigrant intent. You already show immigrant intent. You are on F1. That is a non-immigrant intent. The requirement of a non-immigrant visa and an immigrant visa, the requirement contradict each other. So how are you going to do it? You can't eat your cake and have it. On one hand, you cannot tell them, by asking to renew your F1 visa, you are telling them that, oh, I'm just going there temporarily, I'm going to school. Once I finish school, I will go back home. On the other hand, you are saying, oh, I have this degree, I have this skill, I want you to give me permanent residence because I want to live here permanently. So the requirements are contradictory. So in this situation, based on this fact, I will not even advise you to travel. Next question, please. Are you sure we have not exceeded our time? It's almost...
We've exceeded the time, yes, but we haven't gone to the questions.
Yeah, but I asked you to...
Yeah.
When you asked me, there were already a lot
We
of
had
questions.
so many.
So we have not reached... Okay. Hopefully... So how many more do we still have to answer today? Because at a point, we have to stop. We cannot continue indefinitely. I have another appointment at 2. So how many more do we have?
Okay, EB2, okay. Another jurisdiction, readings.
I just need to quickly set a cutoff because, like I said, I have another appointment at 2. We have to end it. Okay, while you are checking, let me quickly answer the next question. Greetings, sir. As a green card holder with his wife and child here, is there a penalty to file a tax as singles? Please, they had been filing jointly over the previous years. Well, you remember, anyone who is not yet a citizen is still at risk. You don't want to do things that you can, especially now that IRS and DHS are sharing data. A lot of people are going, even people who are married to US citizens, a lot of people file their taxes. Some will claim head of household, some will claim single when they are married. By law, if you are married, you have only 2 ways of filing your taxes. You can file as married filing jointly or married filing single, married filing separate. So those are the only 2 ways, married filing jointly or married filing separate. When you file as head of household, you are telling immigration that you are not married. You are telling them that you are a single parent. Head of household is for somebody who is not married but who has a dependent. That is what head of household means. And of course, single means you are not married. So if you are still not done with immigration, my friend, please, though I don't care how much refund you will be getting, it's not worth the risk. It's not. Because for as long as you are still going to face immigration, and now that immigration is sharing data with IRS, it may be problematic when you eventually apply for your citizenship. If you're already a citizen, there's nothing they can do about it. The worst case scenario, IRS can audit you. Oh, we discover that you are married, and then they audit you, they redo your taxes, and then they slam you with penalties and interest. That's the worst that can happen if you are a citizen. But if you are not yet a citizen, this can become a big problem for you. So I will not do it. Next question, please. So how many do you have left? 8 from the cutoff or 8 total?
No, 8 to the cutoff. To the cutoff is 8 questions.
Okay, 8 questions to the cutoff. Please limit it to that 8.
No.
The other ones will continue next week. Please, next question. Good day, sir. May God continue to bless you for the great work you are doing freely for migrant. Thank you. I submitted my form I-751 in 2021, received a letter that it has been transferred to another jurisdiction in order to expedite action on it. I later received a letter of 48-month extension. The extension will lapse in November. Please, what should I do? Well, the first thing you should do is to check the processing time. If your case is outside of the processing time, then go ahead and do a service request. Secondly, because this is a 751 application to remove condition, go ahead and determine your eligibility for citizenship. One of the benefits of 751 delay is that it does not affect your ability to apply for citizenship. So calculate your years from the date of your initial green card, your conditional green card. If you have been 5 years from that time, go ahead and submit your application for citizenship. Immigration will still adjudicate both of them together. Next question, please.
Oh, and they can get their passports stamped.
That's only if they need to travel. The 48-month extension letter is already received, and there's a probability they will extend it if they know it's still pending. Best thing is to apply for citizenship. Next question. Good afternoon, sir. I booked in-person appointment with you this month end, but I realized that I won't be able to come in person. Can I change it to virtual instead? Oh, yes, you can do that. That's not an issue. Just send us an email and we'll change it for you. Or call the office for the numbers I stated before, 817-274-1144 or 817-274-1844. Next question, please.
You already answered this one, right? The one on the screen?
Yes, I already answered that.
She sent another question here.
Yeah, these are the type of questions that I say I cannot answer here, not even right now. What options does an F1 person have aside EB2, NIW, and H1B as they have tried this already? Like I said, this is an open-ended question. We can't go into that right now. Please go into the next question.
I don't know if we already.
Oh, I didn't have that one.
Okay, question part one, this one.
Okay.
Okay, so there's a second part to this question. The I-751.
Yeah, I answer both.
Okay, you did. Okay, this one then.
If you file an EB petition and it's denied, can you file for the O category, or what will be the best route to take? I don't know what EB. I mean, there are 5 categories of EB, so I don't know what this person means. You have EB1, EB2, EB3, EB4, EB5. So I really don't know which of the EBs.
Question answered?
Someone sent you a gift.
Is it a question?
The yellow one, someone sent you a gift.
Oh,
But I think they want their question answered.
And they have a question, of course.
okay.
So you might want to address it later.
Let me know once I get to that question. So as I was saying, I don't know which of the EBs. There are EB1, EB2, EB3, EB4, EB5. So I don't know which of them. Then secondly, EB petitions are immigrant petition. On the other hand, O visa is not an immigrant petition. O is a non-immigrant visa. So people need to understand all these terminologies before using it. O is a non-immigrant visa. So if you already file an immigrant visa, as I stated before in answering one of the previous questions, that is already contradictory. You can't eat your cake and have it. You can't say you are a non-immigrant who is applying for a temporary basis, intend to return, and then you file an immigrant visa on the other hand, saying that you want to stay here permanently. The two does not align, so it has to be one of the two. So if your EB petition is already denied, the O petition is going to be tough, but it is a possibility. Can you do it? Yes. But can you get it approved? That would be tough. Excuse me. The next question. Please, sir, where is your office and what do I need to get an appointment with you? Please log into our website.
Yeah, it's posted. It's a pinned message.
Okay, can you also post on the screen our website?
Yeah, it's a pinned message on the top of the live chat.
Okay.
Yeah.
They said that our website is pinned to what? To the top?
Top of the
Top of
chat.
the chat.
Okay, it's pinned to the top of the chat. I don't know what that means, but you probably understand it. So next question, please. I mean, I've already said it on the program several times. I'm old school. I'm not IT savvy. So
But you've
people
come a long way.
people will understand that. So, and I'm sure I have a lot of people who are in the same shoes as me. So the next question. Good afternoon, sir. I have a nephew back in Nigeria and I'm responsible for his education and well-being. Can I apply for him as my son? No, sir. We have already explained all that. Nephew does not fall into a child. Your nephew is not your child. For immigration purpose, you can only petition for your child or an adopted child. So if you are going to take over your nephew's situation, you will need to adopt him, assuming that he's still under 16. Because for adoption, you have to do it before age 16. Next question, please. Dear Dr. Asekun, this is a question about what you have often said that an American citizen must show their American passport at check-in for international travel. Please, what rule makes it compulsory? Is it the only question, or is there a continuation so that I can read it together before?
Yeah, this is the
Yeah, that's it.
Okay. Yeah, it is actually the law. I don't know if I have this person's contact. If you can send your email, I can send you the specific law. I don't have it in my head right now, but there is a law that requires an American citizen to go in and out of the country with American passport. That is the law. You go in and out of the US with your American passport. That is the law. But what I said earlier was that for as long as you show the American passport to the airline agent when you are checking in, you have fulfilled that purpose, because there is no machinery in place to check American citizens who are traveling outside the country. It is only when people are coming into the country that they are checked. So that is the position. So it's a requirement of the law that American citizens must travel in and out of the US with American passport. But I will send you the law that says that, but I just don't have it in my head to tell you right off my head.
That's the same thing.
Yeah. Okay, so this one.
Okay, next question. Dear Dr. Asekun, I'm a F4 green card holder from Nigeria studying in the UK for masters, which end in September 2025. My green card had not arrived when I returned back to complete my studies. Is there a part 2? Because I've not seen any question yet. Okay, I want to pick up the green card and return back. Is there an implication at the immigration? No. Let me be sure I'm getting this question correctly. Move it down a little. Let me read the first part. I'm a F4 green card holder from Nigeria studying in the UK for masters, which end in September. My green card had not arrived when I returned. I'm not understanding. You mean when he left, when he departed? Because the way he's asking the question is confusing. Okay, let me read it the way it should be. My green card had not arrived when I left to complete my studies. I mean, this is assuming when he left for the UK. I want to pick up the green card and return back. Is there an implication? How are you going to come back to the US?
He needs to have the green card over there sent to him if he hasn't gotten it yet.
That's what I'm trying to understand, and that's why I'm a little confused with this return back to where? Back to the US? Or so how are you going to return if you don't have the green card with you? You need to get the green card before you can come back to the US, because if you don't have the physical green card with you, you will not even be admitted into the US. You may be a permanent resident, but you still have to show evidence of your permanent residency. So what you have to do, you have to get somebody to bring you the green card. Please do not mail it. Do not mail it. If you mail it, you are not going to get it. I can guarantee you of that. Do not mail it. Let somebody who is coming physically to the UK bring your green card, and then you can use it to return to the US. But if you ask them to mail it to you, you are probably not going to get it, because once they scan it during the mailing process and they see the green card inside, they are going to confiscate it because it is the property of the US government. So you should not mail it, but you need to get the green card physically in your hand. You cannot come back into the US without the green card, because whatever your status was before the green card was approved, upon the approval of the green card, that status is no longer there. So you don't have the status. So find somebody if you have parents here or siblings, let them come to the UK and hand deliver the green card to you, and then you can come back to the US with your green card. Then when you enter the US, go ahead and apply for advanced parole. You don't have to wait for it to be approved, but go ahead and apply, because if you stay out of the US for more than 6 months at a time, it will affect your ability to apply for citizenship. It will affect your citizenship application, and sometimes it can even affect your green card itself. If you stay out of the US for a year or more, there will be a presumption that you are abandoning your permanent residency. So in order to avoid all of that, because you may be thinking that, oh, I will be back in September. Something may happen that may prevent you from returning in September. Then that will be another issue entirely. So the best bet, get somebody to bring your green card to you in the UK, use the green card to return to the US. As soon as you get into the US, apply for travel permit. Once you do that, then you can go back to the US, to the UK, and complete your studies. Next question, please. We have not answered the 8th question. I thought we have.
This is the last one.
There were a couple that weren't on my thing. I think because they've been deleted. I don't know.
Okay, next question. Because now we have now exceeded 2 hours. So we have to end it. I have another appointment at 2.
Right now.
Yeah. Hello, sir. Do I need to fill an I-864 form for my spouse immigrant interview soon at the embassy, who is a derivative applicant of my EB3 application? I adjusted my status and I have my green card for 3 years. Well, I-864, if it is this, did it say EB? Yeah, EB3. No, I-864 is not required for employment-based petitions. So I-864 is not required. Well, I think that is the... Okay. Are you eligible for 212C waiver if you are on F1 student when you commit a CIMT in 1993 and became LPR in 2015? If you are in removal, is there a continuation?
Let me see.
Well, this question is pretty simple, but I need more information. I don't know if this person has a qualifying relative, and this was in 1993. I think the simple answer is yes, but I want to be sure that you have a qualifying relative, because the IIRA Illegal Immigration Reform Act was passed in 1997, and it became effective in April of 1997. So if this one was an issue that came up in 1993, yes, you will be eligible for 212C waiver. But the issue is, do you meet the other requirement for 212C? But the simple answer to your question is yes, you are still eligible for 212C waiver, because the law that changed 212C came into effect in April 1997. And there are tons of authorities that says that the law was not meant to be retroactive. Yes, the answer is you are still eligible. Well, that will bring us to the end of today's podcast. We hope to continue again next week. Next week, Wednesday, remember to invite your family, friends, colleagues at work. And before you go, I want to restate it again for the purpose of those who didn't start with us from the beginning, or those who didn't start with us early. I want to specifically say that if you fall into the category of people that followed our advice on filing taxes when you are undocumented, with this new IRS relationship, with IRS and DHS relationship, if you get into trouble, I'm going to repeat it again. I promise to defend you free of charge. If the only thing you will need to do is to show us evidence that you actually followed that advice when you listen to our podcast. We are in a very difficult situation. We are in a very difficult time, but I'm very, very optimistic. I am hopeful that this period will soon pass. We will survive it, and none of us will be deported by the grace of God. The very last question that I answered, the 212C question, I don't know the person that sent the question, but the person actually sent us a gift. This is very, very encouraging. I want you to know that from the depth of my heart, and of course my team members, we appreciate you. It's very, very encouraging. It is very, very encouraging. And I also want to tell you, once in a while, we do receive calls, we do receive emails, we do receive people who show appreciation for what we are doing. I want you to know that it is very, very encouraging. It is this kind of things that keep us going. It is this kind of things that keep us motivated. No matter how good you are, if people are not appreciating what you are doing, sometimes you may be discouraged. But I can assure you that we have listeners that are very, very appreciative. I think it was last week. Sometimes somebody scheduled a consultation appointment, paid the 150 consultation. When I wanted to attend to the person told me that I just wanted to say thank you. He said, all the questions I have, I already posted it on the podcast and you already answered it. But I just feel like talking to you. I feel like appreciating you. That is why I went ahead to schedule the appointment. You have no idea how much those kind of things encourages us. And like I said, I am going far and beyond my capacity just to ensure that we help a lot of people. And the more people show appreciation, the more we keep going. I really want you to know that we appreciate all the prayers, all the support, the text messages, the email messages, the calls, and all forms of appreciation. I see people, even on the road, once they identify me, oh, Dr. Asekun, thank you for all you do. We listen to your podcast. In fact, I recently met with somebody who told me that, oh, we are a group. On Sundays, we play your podcast as if we are going to a church service. We sit down together and listen to it. I mean, you have no idea how encouraging this type of feedback is. And I pray that God will continue to grant all of us, for us here, the strength to continue to do it, and for you listeners, the strength to be able to do the right thing. I pray that we will not get into trouble, and I pray that at the end of the day, we will look back and say thank you to God for making us survive this administration. We will definitely survive it. The good thing about this country is that there's another election next year. Next year is a midterm. We will see. And all it takes is for the Republicans to lose one of the control of the houses of Congress. I am certain that we will survive it. We will survive. We survive his first term. Donald Trump's first time, we survive it. Definitely this one too, we will survive it. We hope to see you again next week. Until then, remain blessed and keep safe. Keep low, avoid crimes. God bless.